I just wanted to let the court know that Mr. Moore would like another attorney. So we probably have to call and get him yet another attorney.
Can you handle the arraignment today?
Yeah, I can handle I'll do the arraignment, yes.
All right. I mean, he needs to be arraigned, and so, and then we'll let them know that we need yet another attorney.
Yes. I tried to explain to the client that I would schedule it with him so that we could talk at length, and that really upset him. I did explain that, I needed to go to the courtroom at this point and then speak with him on Zoom at a later date, but he wants another lawyer. Okay,
so let me call these the new one first. This is 241976 People versus Christopher Moore. So Mr. Moore, initially you had an attorney that was appointed through NDS, and they had the attorney they appointed was not I don't want to say qualified, but she didn't meet the standards under the Michigan Indigent Defense Commission's to handle a case of this nature. So she was removed from the case because she can't be on that list. Then Miss Watt was nice enough, kind enough today. She was called to stand in on this or come into the case forthwith so that you could have your court date. So I just want you to know what happened today. So now we have Miss Watt here. It was scheduled at 1:15. All we're handling today is the arraignment. So you're being arraigned on your new case. And I've known Miss Watt for many years. She is a very good defense attorney. And obviously those are decisions you can make, at least for the moment. But I am going to proceed with the arraignment. And then if you want different counsel, Miss Watt, it sounds like there's a breakdown.
Yes.
Okay. So, Mr. Moore, on this case, Ms. Watt, can I get your appearance for purposes of arraignment?
Yes.
If she's going to be...
Cora Watt, appearing on behalf of Christopher Moore, P41508.
Okay. So, Mr. Moore, we can get you a new attorney if you want a new attorney, but I'm arraigning you on these charges.
Your Honor, we stand muted the formal reading of the warrant on the charges, Your Honor.
Okay. So, Mr. Moore, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearing. If you can't afford an attorney, one will be appointed to represent you, as Ms. Choate was, now Ms. Watt was. And it's my understanding now that, Mr. Moore, you want to fire Ms. Watt?
Correction. I have witnesses in here. She was not listening to what I was finishing trying to say. I had to stop because somebody else, as you can see, there's other court proceedings going on here with several other judges, several other inmates. Got a basketball gym that we're holding court next to. I have cancer. I just had a seizure while I was in custody at Taylor PD when I was picked up. I was sat in the hospital for 4 days. I was trying to tell her, she's trying to present an argument, and I'm trying to get her to understand, but then she's saying that she didn't have the discovery package. This is all falling on the error of not myself. I'm just sitting here and I was explaining to her.
Okay, well, Mr. Moore, listen, Ms. Watt was appointed to your case 2 or 3 hours ago. So of course she doesn't have discovery. She was just appointed, and that's not her fault at all.
It's clearly not my fault, ma'am. I was asked a question and I was trying to respond. I'm telling you.
All right, Mr. Moore.
All I was simply asking, just let me know when I can speak, please. So we're not.
All right. Well, you have 2 dates within the next 21 days. The first is your probable cause conference, which is set for September 4th of 2024. Following that, you will have a preliminary exam. You are to appear in person at that hearing, and that is September 9th of 2024. And we will get this back down and have another attorney appointed to represent you. Mr. Moore, are you telling me that there's been a breakdown between you and Ms. Watt that you believe affects her ability to represent you?
I didn't say anything. She said that she was going to go back into the courtroom. This is what she said. I didn't even say anything. She said she's going back in the courtroom. Oh, this ain't going to work. I was like, what's not going to work?
I don't speak like that, first of all, Your Honor.
All right. Well, let me ask you, Ms. Watt, instead of Mr. Moore, Ms. Watt, has there been a material breakdown where you can't represent him?
Yes, Your Honor.
All right. So you're being removed from the case.
Thank you, Your Honor.
But I'm setting bond on this case. Now, he currently has a $250,000 cash surety bond on his other home invasion case. This one is certainly even more concerning. So, because now he's gone to home invasion first.
Home invasion? What are you talking about? When did this happen, ma'am, Your Honor? Is there a date on it?
Mr. Moore.
Mr. Moore, listen. You know what, Ms. Watt? I don't want there to be any confusion or anyone to say nobody did their job. So here we go. The allegations are that the date of occurrence is August 12th, 2024. And the witnesses state that on the date at that location, the defendant, contrary to law, committed count 1, home invasion, did break and enter or did enter without permission a dwelling with the intent to commit an assault therein. And while entering, present in, or exiting the dwelling, Shamani Butcher was lawfully present therein and was or was armed with a gun, a dangerous weapon, contrary to MCL 750-110A, parent 2. That is a felony punishable by up to 20 years in prison and a fine or $5,000 fine. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2 is weapons, felony, firearm. The allegation is that you did carry or have in your possession a firearm, to wit, a handgun, at the time you committed or attempted to commit a felony, home invasion first degree, contrary to 750-227B. That is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 3 is weapons, firearms, possession by prohibited person. The allegation is you did possess and or use a firearm when ineligible to do so because he or she had been convicted of assault with intent to do great bodily harm, less than murder, and or uttering and publishing an offense punishable by imprisonment for more than 1 year, and the requirements for regaining eligibility had not been met, contrary to MCL 750-224F, parent 6. That's a felony punishable by up to 6 years and or $5,000. Count 5 is assault with a dangerous weapon, felonious assault. And it alleges that you did make an assault upon Shamani Butcher with a dangerous weapon, to wit, a handgun, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. That is a felony punishable by 4 years and or $2,000. DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750-506A if the assault was committed in a place of confinement. Count 8 is weapons, felony, firearm.
There's the charges on this, ma'am?
I'm still reading your charges. We're on number 6.
I'm sorry. I didn't mean to interrupt you, ma'am.
All right. Well, listen.
Okay.
You want to know, I'm telling you.
Yes, I wanted to know.
Did carry or have in his possession a firearm, to wit, a handgun, at the time he committed or attempted to commit a felony, to wit, assault with a dangerous weapon, contrary to MCL 750-227B. This is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for a felony or attempted felony conviction, mandatory forfeiture of the weapon or device. Count 7 is domestic violence. And the allegation is you did make an assault or an assault and battery upon Shamani Butcher, an individual with whom you have a child in common, contrary to 750 Parent 2. This is a misdemeanor punishable by up to 93 days and or $500. A consecutive sentence may be imposed under MCL 750-506A if the assault was committed in a place of confinement. You are charged as a habitual offender, and there is a fourth offense notice on your information or complaint.
This was all on August 12th at what time, ma'am?
There's not a time on here. It said it's at August 12th at this location. No, I'm still reading, Mr. Moore.
There's more?
Take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies. In that, on or about October 19th of 1995, he was convicted of the offense of stolen property, receiving and concealing in excess of $100 in violation of 750.535A in the Detroit Recorder's Court for Wayne County in the state of Michigan. Listen. And on or about 2/16 in 1996, he was convicted of the offense of breaking and entering a vehicle to steal property over $5 in violation of MCL 750.356A-B in Detroit Recorder's Court for Wayne County in the state of Michigan. And on or about December 9th of 1999, he was convicted of the offense of police officer fleeing third degree in violation of MCL 750-479A3 in the Third Circuit Court in Wayne County in the state of Michigan. On or about 3/31 of 2000, he was convicted of the offense of assault with intent to do great bodily harm less than murder in violation of 750.84 in the Third Circuit Court for Wayne County in the state of Michigan. I'm not done. And on or about 4/26 of 2013, he was convicted of the offense of uttering and publishing in violation of 750.259 in the 44th Circuit Court in Livingston County in the state of Michigan. Therefore, defendant is subject to the penalties provided by 769.12. The penalty is life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty of under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. So that is the information alleging all of the charges or stating all the charges that you have served, as well as giving you notice of that fourth offender notice.
Oh, I'm sorry. Are you done? Ma'am. Your Honor.
Sir, I just want to remind you, Mr. Moore, we're not adjudicating this case today. Okay, this is not a trial. This is not a trial.
I didn't understand.
This is an arraignment. At an arraignment, you are to see and hear the charges against you, which I've now read into the record. And the other purpose is to set bond and notify you of your next court dates. It's not the date where I look at all the facts and the evidence and make any sort of determinations. Today is specifically
because these are all alleged. Bond.
What's that?
Because these are all alleged allegations, right?
Absolutely.
Okay. That's why I was asking you, because I was going to say on August 12th, there's no way that possibly happened.
All right, well, don't say any more. See, now you're trying to talk to me about the case.
That's why I asked you. That's why, okay, so don't say nothing now, because it's not the time to say it.
It is not the time, and anything you say can and will be used against you in a court of law.
I'm not worried about it. I'm not lying about anything. I got nothing to lie about. So that's why I was just asking what it was. So for the record.
Okay, so all right, so Mr. Moore, we'll get you a new attorney. The 2 misdemeanor cases are just going to follow the felony matters. So the 2 domestic violences will just go in and we'll work on those as your case proceeds through the 23rd District Court. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with Sharmani Butcher.
So there's no way of being able to talk to my son in any way, shape, or form either.
Sure. Isn't the son at issue an infant?
He's 19 and a half months old.
Okay, then no, you can't. You cannot possess or purchase or consume alcohol or illegal drugs. You cannot possess or have access to firearms.
I ain't been able to do that for a long time, especially having a son. So,
Okay. So we already did a DSU referral. We don't have the report back. So we'll
What is that?
review all of this at that time, but your bond in this case is $250,000 cash or surety with GPS tether within 2 miles.
okay, ma'am, can I speak now, ma'am? Your
You
Honor?
have a right to remain, you can speak, but Mr. Moore, what I'm trying to explain to you, and I want to make sure you understand clearly, is you have a right not to speak. And any lawyer.
I know, I would choose to speak.
Any
I was
lawyer
just trying to
would tell
be
you not to
respectful.
speak.
Okay, I was trying to be respectful and not cutting you off. I was just waiting for my turn to say something.
Okay, go ahead. What do you want me to know?
Thank you. So, as I was trying to say in these alleged allegations, since I'm innocent until proven guilty, which unfortunately I don't feel like that's the case. However, I was just pointing out to the fact I need to have 2 biopsies and a colonoscopy. I don't know which treatment I can have in here due to cancer. Apparently now I had a seizure and I was hospitalized at Taylor Hospital, which is now known as Corwell Health, 3rd Medical Surgical East, where I had a seizure while being detained in Taylor PD.
Okay.
I have an abscess that's spread and the poison is spraying apparently in my jaw, going into my bloodstream as we speak. They're in the process of opening a new jail. I just went through my 4th round since the hospital of antibiotics. I'm developing an immunity. So they basically said, either the judge is going to either lower your bond or give you a personal bond and put you out on a tether, or we will when you turn around and either possibly.
Okay, well, I'll tell you what. I'll make sure I contact the Wayne County Jail and let them know that your bond is $250,000 cash and surety. I've marked your file medical, but I'll make sure that they know that you are not eligible for release on tether unless you post that bond. I'll make sure they're aware of that.
Well, ma'am, ain't that being a little biased and discriminatory?
No,
So
it's setting a reasonable bond on cases like you have pending. They're allegations, but I have an obligation to keep the community safe. And also, based on all the required lack of appearances, I also believe you're a flight risk. So those are the decisions that I've made. They are within my discretion, and I believe they are appropriate. So we'll see you on September 4th at your next court date. Thank you, Ms. Watt. We'll make sure we get a new attorney sworn in.
Thank you, Your Honor.